What alerted you to the defendant?
Well, again, we were monitoring the racers. I was shooting stationary radar on Military Drive. He was coming the opposite direction. As he was approaching, obviously he was coming at a higher rate of speed than closest speed limit. Closest speed limit was 45 at the time.
And did you happen to find his number on your radar?
Yes, sir. Activated the radar system. He was actually approaching at 54. Actually came in at 56 miles an hour.
Okay. And so you pulled him over originally for
Just speeding.
speeding. Okay. What did the defendant do after you decided to pull him over?
Well, once I initiated the traffic stop, he was activating the emergency lights. He was pulling into, I think it was a security service bank parking lot. A little odd just because of the fact that there was an actual sign that vehicles weren't supposed to enter through that section, but we went through it anyway. Pretty much normal stop at that point, stop within the drive-through bank area.
Okay. And once you were stopped, then what did you do?
Once we were, stopped, just check out on traffic, on the traffic stop via the computer. Just approached the vehicle and contacted the defendant. Initially, when I first contacted him, just informed him that the stop was because of the speeding. The first observation I made was that his eyes were bloodshot and glossy. At that point, I asked him for a driver's license. I asked him also, perhaps if he had drank any alcohol. I explained to him that the reason I was asking the questions because of the fact that his eyes were bloodshot and glossy. He informed me that his eyes were irritated because of at that time, everybody remembers that there's like that African dust. They burned the crops in Africa and the dust drifted all the way over here. So deciding that was the issue with his eyes.
Okay. What did at that point the bloodshot eyes? What does that indicate to you in your training?
Well, that's usually one of the cues that we can observe if someone's been consuming alcohol.
Are there any other cues that you observed this night when you after the eyes?
Yes, sir. Just there was a pretty good strong odor of toxicants that was being emitted from the cabin of the vehicle. Aside from the defendant, there was a passenger within the vehicle. But that's the reason why, between the bloodshot, glossy eyes and the odor I was detecting, so led me to believe that he consumed alcohol.
So when you had the suspicion, then what did you do?
Well, just based off of that, again, I asked him if he had consumed alcohol and he denied it. But after that, I just went ahead and asked him to exit the vehicle just to also to kind of verify whether or not the odor I was detecting was coming off of him, or maybe it was the passenger. Once out of the vehicle, I was able to verify that it was coming from his breath and his person.
Okay. And when you verified that, what was your next step?
Well, at that point, I had him facing away from my patrol car. I began to prepare him for the first field sobriety test, which the horizontal gaze and status. First thing I did there was just to qualify him, make sure asking him a few health-related questions to determine whether there wasn't going to be any issues that could, give me a false positive, as far as head injuries or such.
And what is the horizontal gaze nystagmus?
The horizontal gaze nystagmus test, it's the first test that we typically administer. What we're looking for basically is nystagmus, which is the involuntary jerking of the eye. Everyone has it present, under normal circumstances. The only thing is just that under normal circumstances, when you're looking for that, you really can't see it with the naked eye. It's very rapid. The actual jerking of the eye is controlled by the smooth muscle tissue. So it's something that a person doesn't really exactly have control of. The only thing with what we're checking for at that point, and if it's visible, is because someone, introduces a depressant, a CNS depressant, such as alcohol into their system. Once that CNS depressant is they ingest it or put into their body, basically it slows that jerking so it becomes visible. There's enough of it, to become very apparent.
So with that, when it's visible, it's an indication that there's an intoxicant in the system.
Yes.
Okay. And do you recall? Is there a certain amount of clues?
Yes, sir. And it's just as per the, our training that there's 3 possible clues in each eye, so it's 6. One of the clues will be the lack of sleep pursuit. The second one is the nystagmus at maximum deviation, and the third one is the onset of nystagmus prior to the 45-degree angle.
And that's for each eye.
That's for each eye. Yes, sir.
Okay. So for a total of 6.
Yes, sir.
And how many do you need to see before you know there's an intoxicant?
Well, I mean, as far as to determine whether the person's intoxicated.
Yeah.
Okay. Well, in order to determine whether someone's intoxicated, they're looking for at least 4 or 2 in each eye.
And what did you perform this test?
Yes, right.
And you qualified the defendant?
Yes, we really qualified.
Okay. And how many clues did you find in the defendant?
We had all 6, 3 in each eye.
Each eye. Okay. And when you found those clues, what else did you check for? What was the next part of your investigation?
Well, also included in the HGN test is also we check for vertical nystagmus. So that's the last check where basically we take the stimulus and just raise up a foot above their eye level. Vertical nystagmus is basically typically if it's observed, which is not always observed in every person. It's an indicator someone would possibly use something else other than alcohol, or the amount of alcohol that person consumed individually is more than enough for them.
Okay. And so after you did that, what was the next step of the investigation?
After what happened at that point with this case was that as I had administered the test, I realized that my flashers and strobe lights were on. Second of all, unfortunately, I hadn't activated. I thought I had activated my body cam, so I went ahead and reactivated the body pool, activated the body cam at that point, and I had also shut off the strobe lights and flashers. That's the whole, to prevent the optokinetic nystagmus, which was not an issue in this case. So I went ahead and re-administered the HGN test the second time, just for the sake of having it on the body cam, and then with the same result as the first.
And that was to avoid, you said you shut off the flashing lights?
Yes, sir.
To avoid.
Flashing lights.
Okay. And you did that so you could preserve the evidence for the court, right?
Yes.
For the jury to review. So you did have body wear cam?
Yes, sir.
And at that point, you started it and redid the HGN.
Yes,
What did you do after that?
After the HGN test, again, I had asked the defendant a few other health-related questions because of the fact that the next 2 tests are going to be the walk and turn test and the one-minute stand test. Those are both divided attention tests. They're divided between the mental and physical faculty.
And those are part of the standard field sobriety tests from NHTSA?
Yes, sir. Yeah.
Could you tell us about the walk and turn test?
The walk and turn test, there's 2 phases. There's the instructional phase and the actual performance part. During that test, you're basically sometimes you're out in the field. Sometimes you'll have the suspect or the defendant use an imaginary line to follow line that's gonna be roughly the width of the foot, as a guide. In this case, we were, nice flat smooth surface so that, bank, mobile drive-through. So it was nice and flat and smooth and dry. There was a concrete, control joint, which is, nice and straight, so I had him use that as a guide. Well, the first part is just basically putting him into that, standardized position of, standing, right foot in front of the left foot, touching the toe, hands at their sides, and we tell them, instruct them that to maintain that position, not to move from the position until we instruct them to do so. Once you place them in that position, we then proceed in, giving them the verbal instructions. And then we'll actually give a demonstration, which involves just 3 steps, just because it's the sake of the area that we work in. Once we give them the instructions and give them an example, then, we'll ask them if they have any other questions. If they have any questions, we'll allow the performance test.
Okay, you said divided attention.
Yes, sir. The walk and turn test and the one stand test, basically they're meant to, basically test someone's mental and physical faculties. When you're driving, you need both the mental and the physical faculties to be on board in order to operate a vehicle safely. If you're driving down the street, you want to make sure you're looking ahead and you're watching, making sure you're pressing just the amount of pressure on the accelerator. So you need to have all that on board in order to operate a vehicle properly. Even using the cell phone, I'm sure everybody here has done it. That can take away from that, and it's pretty much the same thing as with alcohol. Introducing of alcohol, it'll slow your reactions. So these tests, the walk and turn test and the one stand test, are meant to basically try as best to mimic what you would need in order to operate a vehicle safely.
Okay, you said 2 phases.
Yes,
The first phase was,
the instructional phase.
and so does that test the mental faculties?
Yes, sir. It'll test both the mental and the physical. You tell them or instruct them first, not move in position until they're instructed to do so. Physically, they're trying to, hold that heel to toe, with their hands at their sides, and hold that position. The other thing is just that you tell them not to start until they're told to start. So mentally, they're having to concentrate about those things. Those are the 2 basically clues of intoxication that could be present during just that phase alone. And again, after that, we'll give them the example and then allow them to proceed to perform the test if they don't have any other questions.
Okay. And in this part, could injuries affect this?
Possibly, but typically, that's the first thing, as officers were first to ask. We want to try to rule out, again, that, there's a possibility to have an issue. It wouldn't be fair to that person if they actually have an issue with, perhaps like a torn, ACL or, broken leg or something. It wouldn't be fair to administer the test to that person.
So in this case, did the defendant tell you about any injuries?
Initially, he had, before performing the test and being placed in that position for the walking turn test, he had stated that he had been injured. I think he said he fell off of the ladder or something while he was working. He was, stating that he had done that. But what I found was odd is as he's explaining that to me, he's basically balancing himself on his right foot and kind of hopped around on it. And that's the right way. But he stated was the injured foot. And so it was kind of like, okay, you're injured. How did you do that? So we went ahead and I went ahead and proceeded in administering the test anyway. Since he was displaying, the fact that he was able to do all that.
So under your training and expertise, you believed he was physically able to do it?
Yes.
And then you did do the walk and turn?
Yes.
What about the second phase?
On the second phase, that's the actual part where they actually perform the test. During that phase, they're supposed to take 9 heel to toe steps forward. As they're walking, taking their steps, just kind of step out loud, focus on the steps or focus on the lines that are given. Leave their hands at their sides. Once they start, they do not stop. And we also show them that to make the turn to come back and take the return steps, there's an actual, method of doing that actual turn. And we'll actually explain it to them and actually demonstrate how to make the turn. And then we're supposed to return, doing the same thing, heel to toe, focusing on the line, counting each step out loud, moving their hands to the sides again, and to not stop. And so once we give them those instructions, give them an example, then they're allowed to begin if they have any questions.
Okay. And how many clues total for both phases in the walk and turn test?
Between the 2 phases, there's a total of 8 possible.
And do you recall how many the defendant displayed?
No. I know it was at least 4 to 5.
Did you do a police report?
Yes, I did.
Would reviewing your police report help refresh your memory?
Yes.
Your Honor, may I approach?
You may approach.
Oh,
Have you had time to review it?
yes.
Did it refresh your memory?
Yes.
And how many clues did you observe during the walk and turn?
Between the 2 phases, there was a total of 5.
Okay. And which ones were those?
He couldn't keep his balance during the instructional phase, and then the other 4 were during the actual performance phase. He didn't touch heel to toe on some of his steps going out and returning. He stepped offline, during the time that he took the steps going out and returning, and then he turned in correctly. And the number of steps he took they were off. There's supposed to be 9 heel to toe steps going and 9 heel to toe steps back. He did 11 going out and 11.
And under NHTSA, how many clues do you need to see to tell whether someone is intoxicated?
2.
2.
Yes.
And that's enough to indicate intoxication.
Yes.
After you did the walk and turn, what was the next part of this investigation?
After the walk and turn test, we did the 1 extent.
Okay, and could you explain? I know you said it was a divided attention as well.
Yes.
Will you go into the details of what that test is?
During the 1 extent test, we have them stand pretty much basically going by that attention and the sides, the feet are together. Then we'll go through the whole again the instructional phase and then we'll actually demonstrate how they're supposed to perform the test. During the performance of the test, we're asked if they raise whichever leg they feel strongest, supporting themselves. Obviously, we're going to use that leg. They'll raise whichever leg they want, 6 inches above the ground, keeping the parallel with the ground. As that foot is raised, tell them to focus on the foot that is raised, to leave their hands at their sides, and to count out loud in the manner of 1001, 1002, 1003, 1004. We're asking them to count out loud until we tell them to stop. It is a time event. It's standardized for everybody. It's 30 seconds. During that time, what we're looking for is basically to see if they follow those instructions.
And you did that test with the defendant.
Yes, sir.
And can you tell the jury what the results were?
Yes, on this one, we actually displayed 3 possible forms of intoxication up to 4. Use designs for balance and hop and display.
Okay, and how many clues will indicate intoxication?
Per NHTSA, I would say 2.
Per NHTSA, okay. At this point of your investigation, did you believe that the defendant was intoxicated.
Yes,
And this was based on the results.
based on the totality of circumstances. I took the results of the, the field sobriety test, the contact with them. Initially, like I said, he denied consuming alcohol. Right after the HGN test, my experience over the last 12 years, being a brain, I knew he had consumed alcohol. So I asked him to be honest, and he admitted to consuming one. He claimed it was one 24-ounce can of beer. Also, not being a clue of intoxication, but I asked him a simple question: "What time do you think it was?" And he said he had just left his friend's house. At that point, when I asked him, he thought it was like midnight. It was only 9 o'clock. So, just again, it's just based off of the circumstances that they involved.
And when he finally did admit to having drank, what time did he say he last drank at?
I believe he said it was somewhere like around 7:30 or something.
Okay. Do you need a refresh?
Yes. Yeah, he said around 7.
Okay. And it was, the actual time was 9 o'clock. Okay. And so you got reasonable suspicion, probable cause that he was in fact intoxicated.
Yes.
And when you pulled up, he was driving the vehicle.
Yes, sir.
Okay. And that reasonable suspicion, probable cause was based off of NHTSA.
Yes.
Your Honor, I have to object to the leading question.
Sustained.
Would you explain exactly what NHTSA is?
Again, NHTSA is the National Highway Traffic Safety Administration. Basically, they publish a lot of the, information in regards to traffic safety.
Do they do any studies?
They do studies, yes, sir.
And did they come up with these standard field sobriety tests?
Yes, they did, because basically it was to help standardize how we, as officers nationwide, would conduct a test under, any type of circumstance, for the most part, out in the field, because, the field sobriety test, because you're not just gonna have the, a lab where everything's perfect. The weather can be affected. So the studies from NHTSA were based off of areas like Colorado, Texas, Florida, California, even Alaska. So they're basically just standardized for all of us as officers nationwide.
And those standards are adopted here in Texas.
Yes.
Okay. You said you had body work cam
Yes.
and it was operating that day.
Yes.
May I approach?
You may.
The state is handing to the officer what has been previously marked as State's Exhibit Number 1. Officer Flores?
Yes.
Do you know what that is?
Yes, it's a copy of the body worn camera video.
And how do you know that it is a copy of that video?
That's my signature on that.
Did you review it?
Yes, sir.
When you reviewed it, is it a fair and accurate representation of what occurred that night?
Yes. Yes.
Okay. The state moves to publish or to enter into evidence State Exhibit Number 1, Officer Flores's body wear count.
State's Exhibit Number 1 is received and admitted, and you were asking to publish that?
And the state would like to publish it. Your Honor.
That is granted.
The state is now publishing State's Exhibit number 1, the body wear cam. Officer Flores, is that your body wear cam?
Yes, sir. it is.
See the edge of your vehicle? Below that, we'll sit down, I'm gonna check the area one more time. Make sure. Yeah, not on the floor, right on the edge. Oh, it's overhead, overhead. Yes, sir.
The state is pausing the video at 52 seconds into the video. So the beginning of this video, Officer Flores, you mentioned in your testimony that you had already done an HGN once, but then realized that you had forgotten to shut off your lights.
Yes, sir.
So this is after that.
Yes, sir.
And the video starts after you have qualified him for the HGN.
Yes, sir.
Okay. And you just wanted it to not have the lights on, right?
Yes,
Your Honor,
sir.
I move to object again to the leading question.
Sustained. And please use your microphone, Mr. Lowry. Thank you.
Sorry, Your Honor. So this is after everything is set, correct?
Yes.
We're going to resume the video. At this point, Officer Flores, is this the HGN that you're going to administer again?
Yes, sir. Actually, I'm doing the qualification again. When I'm holding the stimulus, I'll check for equal people's size. The first 2 passes that I make go through checking for equal traffic. And proceed to the test.
Okay, perfect. Thank you. State is resuming video.
So how much did you drink? Sure. There's some strong beer. I'm sorry, sir. When I check your eyes up, I'll be honest, I've been doing makeup tries for, that's my primary goal. I know, Every night, I've been doing for over 10 years. I know. And I know you didn't like just one. No, I did, I said a big one. That's it. I'm not going crazy. And also, I mean, you can have one medication too. But that helps, so I think, but that was pretty far. That's the thing. How long would it take to wait? That's why we feel. I was at work. And I fell down because. So which was the one that started? So you still working? Yeah, I'm still working. I just changed my light bulb and I was trying to switch it out. And I was going down. I slipped the film. And I moved pretty good. Well, yeah, because I'm wearing my boots. It's on the grip of my ankle. I was wearing my Converses. Just your ankle? Yeah, just my ankle, yeah. But it still sprained all this part right here. Yeah. Let's see something. You see that line over there? Just kind of that line over there. No, that. Yeah. Down the line. Okay. What we're gonna do now is you're gonna put your left foot on the line. Push the left foot up. And now push the right foot from left foot. Touch your toe. Heel to toe. This. And now keep your hands at your sides to your hands. I thought you said the first foot for you. Yeah, but. Very good. Put your left foot on that line. Just the right foot for the left foot, touch your toe. Hands at your sides. Hold that position. Don't move from there. Don't do anything. The time comes, you're going to do is you're going to take 9 heels to steps forward, turn in for straight man, and come back. 9 heels to steps back. As you're walking, focus right on your steps. Count, each step out loud so that I can hear you. Leave your hands at your sides and once you start, you're going to stop. Wait. So that's the difference. You start. Take 9 heels to steps forward. So turn to I'll show you. Come back. 9 heels to steps back. Focus your eyes on your steps. Count and step out loud so I can hear you. Leave your hands at your sides and once you start, you're going to stop. Understand that? Reverse step backwards? I'm going to show you. Watch what I do, okay? I'm taking 3 heel to toe steps. Go take 9 heel to toe steps. First steps with your left foot. 1, 2, 3. When you reach your 9th step, move that front foot line in with your rear foot, take a series of small steps. Turn, come back. 1, 2, 3, all the way to 9. Okay, so the 9 steps forward, and then I do backwards, right? Coming back. You're not coming backwards. You saw how I did it. No, 9 heel to toe steps forward, turn the way I showed you. 9 heel to toe steps back. Eyes focus on your steps. Counting step out loud so I can hear you. Leave your hands at your sides and once you start, you're not stop. Right? Okay. Good. You understand the instructions? You said left to right. No, like left to right. Start from this position. Following the line. Not going that way. Okay. It's your right foot from left foot. You good? I'm sorry. Time to practice. Okay, right foot in front of the left foot. Start. Do you understand the instructions? Do you understand the instructions? Okay, if you understood the instructions and don't have any questions whenever you're ready, you can go to start. Can I stop straight or whatever is comfortable for you, just follow the instructions. Ready? Nice to meet together, hands at your sides. Nice to meet you, about one nice stack, that's what I asked.
The state is pausing the video at 9 minutes and 20 seconds. Mental faculties, the instructions that were given, did you, you tried to help him to understand them correctly, correct?
Yes, sir.
You even repeated them. Did you repeat them?
Yes, sir.
Did you slow the speed in which you said the instructions?
Yes, sir, I did.
And that was the walk and turn. Was that the walk and turn?
Yes, it was the walking.
Where you saw how many clues
So 5.
of,
It was, in actuality, it was actually 6. I didn't mark the 6th one. Because he actually started before I told him to start. You can hear me tell him and he couldn't start. So I actually forgot to put that one in.
but there were more than needed to show
Yes.
intoxication, loss of mental physical faculties.
Yes, sir.
Okay, and then this next part is going to be the one leg stand.
Yes, sir.
The state will resume video.
Good foot braces. I want you to focus your eyes on the foot that is raised. Keep your hands to your side and count out loud. That was 1, that was 2. What is the best leg that probably will support you? Find out the way you showed me earlier, how you fell, and you didn't look like you're in much pain. It's up to you. I'm gonna show you though, hold on. In that position with your hands at your sides, raise your foot 6 inches, just like that. Focus on it, count out loud. That was 1, that was 3, that was 4, that was 5, that was 6. Keep your hands at your sides. Understand the instructions? Understand the instructions? Any questions? You understood the instructions?
The state is pausing the video 10 minutes and 41 seconds in. Officer, which leg did you tell the defendant to use, or which leg did he have to use?
To support himself,
Yeah, for this one leg stand.
I would have been, since you were complaining about the right on hurrying, I told him it was probably best to use the other leg.
Okay, reasonable.
Yes, sir.
Do you remember which leg he decided to use?
Well, I think, given the instructions, it looks like he's putting most of the weight on his right leg already. So while I'm giving him the instructions, it looks like he's putting most of the weight on his right leg.
And the state will resume the video.
So I don't have any questions. Whenever ready. Go. So no, you gotta keep going to that figure stop. Hold on, now, I'm gonna restart it. Okay. Again, hold on. You gotta raise your foot, whichever one you want, 6 inches. Focus on the foot that is raised. Keep your hands at your sides. Count out loud. 1,001, 1,002, 1,003, 1,004. That's how I'll take a stop. Understood? No questions? Okay, whenever ready. makes sense, so you said that was the leg that hurts you,
Oh,
right?
yeah, it hurts really bad right now.
Why would you use that one to balance yourself?
I had to because it's the only thing that sits up straight. This one's not gonna be high, it's gonna fall down. And you just hurt my leg. Oh.
Is it?
Yeah, I'm done. Sorry.
How did you drink beer? What brand of beer were you drinking?
Sorry. That was well done.
What time it is without looking at your watch? You know what time it is without looking at your watch?
Right now?
Yeah.
My best friend.
Yeah. When did you eat last?
The last thing was a half salad.
And many hours sleep?
The last hour is that ESL teacher. It's like I just great. 6 hours. It has a problem. 6 hours.
Okay, man. Do me a favor, I'll switch to my car.
The state is pausing the video 14 minutes and 37 seconds into it. Officer, at this point in your investigation, did you believe, based on totality of the circumstances and the standard field sobriety test that you did, that the defendant was safe to drive?
No, I didn't think it was safe.
And that was based on the signs of intoxication?
Yes,
So at this point, what did you do?
at this point, I'm gonna put some on the grass.
Okay, and that's what you did do.
Yes,
Okay. And you did that because you believed he had lost his mental and physical faculties by introduction of an intoxicant.
yes.
Sorry, just one more thing. You said you were working a road,
Yes, sir.
and you were there for a specific time,
Yes, sir.
for an event.
Yes,
So your police report has more than one date in the date lines. How do you know it was September 1st?
well, I know that on the for one, if we can use it, the test, the date stamp on there, but the other thing was the fact that the complaint form was signed on the 1st. When we go into the magistrate's office, before we turn in, the clerks, they're very strict about it. So the date that's stamped on there is the 1st.
So the other dates, you fill out your own reports.
Yes.
How do you do that?
Well, we have a template that we use. There's, on this one, I know I made a, error on the date. was the 29th, I think is what I put, the actual complaint form on the first.
No further questions. We pass the witness, Your Honor.
All right. Are you all okay? Do you all need a 5-minute break? Is everybody okay? All right. You may proceed.
Your Honor, I believe there were several jurors. I believe there were several jurors nodding their heads.
Oh, I didn't see that. Thank you. Okay, let's get up and walk around for about 5 or 10 minutes. And if you all are cold, if you have anything that you want to bring back with you, I think it's getting cold in here.
Would you be able to go to the restroom?
I'm sorry.
Could we take a brief restroom break as well, Your Honor?
The cold makes me sniffly, so I'm gonna go get something too.
Feels like they wanna use the courtroom as a refrigerator.
Officer, if you'd like to get down and walk around, that's
Oh,
Okay.
thank you.
are you okay. Okay. Do you have some water? Do you need anything? Could you use the water? Okay. I just spilled mine. So that's one way to get the cap off, right? Just drop it on the floor. Let me get you some water. I'll go get some. Sorry. Oh, okay, great. All right. It's just tiring sitting for a long time.
Well, I woke up. yesterday, Wednesday, woke up Wednesday, 6 in the morning.
Uh-huh. Yeah, it's just, we're just not back to normal yet. I mean, I wake up at crazy hours of the night. And then I'm tired all day. It's because I think I feel sleep deprived.
Yeah,
So,
this is my 13th year of working nights. Up, getting close to that 50 mark. It's the last few years it's taken its toll.
yeah, it's not easy.
No, it's not. The first 10 years in Philadelphia, of course, despite COVID, we haven't, our hours never changed. Our
Exactly.
job has
What do they call y'all? Essential or?
essential work.
Yeah.
This business is
So you
still
did
booming.
not have a break.
No,
Yeah. Well, thank God you're still here.
yeah, yeah, I caught it back in December. Right before Thanksgiving. It wasn't that bad. I actually thought I felt like I was in a heart attack. I never had a heart issue. Second
that's
day,
scary.
yeah, second day, and I was so weak. 3 days
Oh.
later, I was running 3 miles. And
Well, see that it pays off to be healthy to
Yeah.
begin with, right?
Yes.
Your recovery is faster.
Yes.
I'll be right back. I couldn't get my bottle open, so I dropped
Oh,
it,
no.
and that opened it.
Did it break it everywhere?
No, it just spilled all over the
Oh,
floor.
darn.
Gonna get some napkins. Fool around with mine, but I couldn't figure out what to do. Yeah, it's just that with this pandemic, I think everything's just gotten not updated, but more confusing.
Yes.
All right, the jury. Maybe seated. We're going back to session.
Okay,
Honorable Judge Gloria Saldaña preside.
so off the record, we brought out a couple of sweet candies if you all are willing or want to indulge, if you'll pass it around. Okay. All right. We're going to go back on the record and I think Mr. Nettles, you may proceed.
Thank you, Your Honor. Just want to double check if this is on, right? Now, officer, you have your police report in front of you, right?
Yes, sir, I do.
Now, you write this report shortly after the incident occurred, right?
Yes, sir.
And often, would you agree with me that whatever you write in that report, it's gonna be more accurate because it was so close to the time of the occurrence than your memory of it today?
For the most part, yes, sir.
And I mean, it is important that it's accurate, right? Because you're here today testifying, refreshing your memory from that report, right?
Yes, sir.
And in fact, you have to swear on the page that's titled DIC 23. You have to swear that everything is true and correct to the best of your knowledge, right?
Yes, sir.
You do that under oath.
Yes, sir.
So, officer, you'd agree with me that there are at least 3, maybe 4 different places where you have the wrong date written in your report.
Yes, sir.
And so we have August 29th written in several different places, but you testified that September 1st is the correct date.
Yes, sir.
Now, does the date September 1st appear anywhere in your physical report? Or did you have to look into this further to figure out what the correct date actually was?
On the booking sheets, it has date of occurrence September 1st. The date of arrest also September 1st.
So on the booking sheet, do you complete that or is that completed by jail staff?
That's mine.
You complete the booking sheet?
Yes, sir.
Okay.
The only one I don't complete is the ID sheet. I mean, I complete it. It just requires one of the detention guards to sign off on it.
Officer, when you encountered Mr. Hiller's vehicle, obviously, I guess initially you don't know it's Mr. Hiller, right?
No, sir, I didn't.
So you're just doing stationary radar, trying to catch people speeding, right?
Yes, sir.
And so, what kind of a radar do you use?
It's the DSR Stalker 2.
And how often do you, check that to make sure it is an accurate machine, getting accurate readings?
Before every use of it, before every tour of duty, they'll conduct a self-system check just to make sure that it's, functioning properly. After that, since we're assigned, essentially we're the third shift traffic unit, we're all assigned to have our own tuning forks. One's a 40-mile-per-hour tuning fork, and the other's a 25-mile-per-hour tuning fork. So with those, once we go through the self-system check, we'll use the tuning forks to make sure it's within proper range, which in this case it was.
And so you have to use there's a system self-check, there are the tuning forks, you also have to calibrate it depending on which direction you're gonna be pointing the radar, correct?
Yes, sir.
And so did you do those calibrations for same-way traffic as well as opposing-way traffic?
The self-system check was ran, and then it's just we don't actually have any way to calibrate it ourselves other than the fact that you just hit a button to set it, whether it's flowing with traffic or it's oncoming traffic.
Officer, I guess they're having trouble hearing us on the Zoom.
Sorry, what did you just say, Counselor?
I just said, I apologize. I guess they're having trouble hearing me on the Zoom.
Yes, sir.
The deputy had asked me to move the microphone.
That's why I asked everyone to please use a microphone.
Yes, Your Honor. Now, officer, looking at your report, that's in front of you, is any of the things you just said about using a tuning fork, checking the self-calibration, or doing the calibration to ensure same-way traffic as well as opposing-way traffic is done correctly? Is any of that mentioned in your report?
I don't think it is. No, sir.
Okay. So this incident was over 2 years ago, correct?
Yes, sir.
And so you just said that, you put everything in your report, make sure you remember it, right?
Yes, sir.
Now, after you activate your lights and attempt a traffic stop on Mr. Hiller's vehicle, you testify that he pulls into a driveway with a do not enter sign, right?
Yes, sir.
And I believe you said it was for a security service, a credit union or security service bank.
Yes, sir.
Was that bank open at that time?
No, sir, but there's typically like a 24-hour ATM there, so.
Okay.
Still.
Now, when you initiated your emergency lights, did Mr. Hiller slow down the speed of his vehicle?
Yes, he did.
Okay. And did he promptly pull into that parking lot?
I think for the most part, yes, sir.
Okay. And officer, when you initiate a traffic stop, you want that person to pull over you want them to both pull over quickly, but also pick a safe place to pull over, right?
The safety is the first part. That's the most important part. Yes, sir.
Okay. So you want to make sure that he pulls into a safe place where you guys don't have to worry about, like a truck or another vehicle on the roadway striking you all the way on the side of the road, right?
Yes, sir.
So he did that, right?
Yes, sir.
And when you began speaking with him or you approached the vehicle, would you agree with me that one of the first things he says to you is basically an acknowledgement that he was speeding and an apology?
Yes, sir.
Okay. And would you agree with me that Mr. Hiller was compliant and polite with you?
Yes, sir, he was.
And in fact, you have a section in your report where you check little boxes for cues or just different things you observed, right?
Yes, sir.
Okay. And so on that checkbox, you did in fact check cooperative and polite, right?
Yes, sir, I did.
And on those same check boxes, there's a category for speech. Is that correct?
Yes, sir.
And under that, you check fair.
Yes, sir.
And so you'd agree with me, in your entire interaction with Mr. Hiller, that he did not demonstrate that he did not have or exhibit slurred speech.
None that I could recall. No, sir.
Now, officer, you said you've been a police officer for 15 years, DWI task force for 12, right?
Yes, sir.
So in those 12 years you've been DWI task force, would you say that you've encountered intoxicated persons tens of times, hundreds of times, thousands of times?
At that point, or at this point?
At this point, 2019.
You're talking about number of arrests?
Just number of intoxicated persons you've encountered.
I mean, if I encounter an intoxicated person for the most part, I mean, it's just an arrest.
Okay.
But, at that point, I was getting close to 2,000.
Okay. So you'd agree with me that red bloodshot eyes, slurred speech, those are the most common cues that you observe.
Yes, sir.
And so you did state that you observed red bloodshot eyes, but again, did not observe slurred speech, correct?
Yes, sir.
And when you asked Mr. Hiller about his eyes, about why they were red and bloodshot, Mr. Hiller told you that he has pretty bad allergies.
Yes, sir.
And he told you that he had taken a Allegra D or some sort of an allergy medicine.
Yes, sir.
Now, did he say he had taken that shortly before driving, or did he say that this was a day ago, 12 hours ago?
I don't recall specifically when. He just did state those prior to the contact.
Okay. And officer, I believe you testified. Earlier that this is around the time that we all may remember that African dust cloud, right?
Mhm.
And let me just ask you, officer, do you have any allergies?
Yes, sir, I do.
Okay. And so does the African dust, did that affect you as well?
I don't recall if it did or didn't. I'm pretty sensitive to everything, though.
But you would agree with me that around that time it was, I guess, a rather highly publicized, allergy epidemic?
I don't know how it was affecting allergies, but I do remember that it was something that was occurring.
Okay. Now, officer, you said it's been a long day, right?
32 hours already.
So when you have these long days, your eyes ever become red and bloodshot?
I'm sure they are right now.
Okay. That doesn't mean you're intoxicated, right?
No, sir.
No, you wouldn't be in here in front of the jury intoxicated, right?
No, sir, I wouldn't.
Okay. So you would agree with me then that there are innocent explanations for red bloodshot eyes.
Yes, sir.
Now, when you were talking with Mr. Hiller, he stated that he was trying to get his girlfriend home because she has a very strict father with a curfew, right?
Yes, sir.
And when you encountered the passenger in this car, did she seem intoxicated?
She made some off-the-wall comments that I remember that didn't seem to coincide with someone who was, not under the influence.
Okay. Now, officer, I'd like to direct your attention on the police report you have in front of you. One of those pages at the very top is a list of witnesses, or witness/passenger/other information. Do you see that page, officer?
Yes, sir.
Now, do you see kind of in the middle, under, I believe it says found evidence of intoxicants and there's sort of a like narrative that you put in there, right?
Yeah, another typo. I have slurred speech in there.
Okay. So that says slurred speech, but you did not observe slurred speech.
No, sir. You can listen to the video. I mean, it sounds pretty clear.
Okay. And so what happened here? Do you just copy and paste from one report to the next?
Not necessarily. It just could be fatigue. Like, I'm sure if I go write a report tonight, I'm sure I'll probably have a mistake here and there too.
Now, when you encountered Mr. Hiller, did he appear nervous?
Yes, sir. For the most part, yes, sir.
Okay. Now, officer, have you encountered persons before that you do not determine to be intoxicated, who are nervous just to be around you?
Yes, sir.
Do you encounter people that are nervous because you have pulled them over and are encountering them?
Yes, sir.
Now, officer, in those, thousands of DWI investigations that you've done, have you ever just encountered someone that just cannot follow directions?
Yes, sir. I have.
Okay. Does it always mean they're intoxicated?
No, sir.
Some people are just difficult or spacey or, frankly, just dumb.
I wouldn't want to say that they're dumb. A lot of the people I've encountered, there's usually an issue of nerves,
Okay.
or there's been some that have a mental issue.
Okay. So being nervous can affect your ability to listen to instructions, right?
Quite possibly, yes, sir.
Okay. And so you have previously testified that these are divided attention tests, right?
Yes, sir.
And the idea is you're supposed to divide someone's attention, make them do one thing while listening to something else, and you try to trip them up, right?
It's not to try to trip them up, it's just to test them.
Okay.
It's not something that was set personally. These are the instructions we were given.
Okay. So the idea of these tests is to divide their attention, correct?
Yes, sir.
And you just testified that someone could still be completely sober, not under the influence, but just by pure nervousness, not be able to follow these instructions.
Yes, sir.
Now, officer, let's talk about field sobriety tests. Now, you performed the horizontal gaze nystagmus test on Mr. Hiller twice, right?
Yes, sir.
Okay. The first time you do it is not on camera, correct?
Yes, sir.
Okay. And you said that you were concerned with, you had your forward-facing strobes or flashing lights, right?
Yes, sir.
And so you were concerned that there was potentially interference with optokinetic nystagmus, right?
I wasn't concerned with it because of the fact that he was focusing on the stimulus, which is the tip of the pen. But I knew that if the case were to end up going to court, if I did arrest him, that it would be something that would be raised. So just to make sure, for the sake of getting rid of that, that's why I went ahead and repeated the test without the flashing lights and strobe lights.
No, when you are asking someone to do the standardized field sobriety test, you're discussing their instructions, you tell them it's for their benefit, right?
What again? I'm sorry.
When you're asking someone to perform the field sobriety test, you're telling them that they're about to perform it. You'll tell them that it's for their benefit, right? To show that they are safe to drive.
No, I don't do that. I try not to make it so that they become nervous. I think I pride myself as an officer to not come down heavily on somebody. So I know it's contact with an officer is nerve-wracking for normal people. So I try to make it real calm. So kind of telling them it's to their benefit. It's like you're trying to load it up so that They're gonna get super nervous and, make mistakes.
So you did not reperform the horizontal gaze and nystagmus test to make sure you had an accurate result. You reperformed it to make sure you had evidence to show this jury.
In the event that if I just decide to arrest him, yes, sir.
Now, just objectively, not in this particular case, but just generally, the NHTSA manual advises you to deactivate all strobe lights that could be in the line of sight of the person you're having perform this test, right?
Yes, sir.
And you're instructed to do this according to the NHTSA manual because there can be interference with optokinetic nystagmus, right?
There can be, yes, sir.
And you're supposed to position them away from strobe lights, flashing lights, or moving traffic, right?
Yes, sir.
Now, officer, let's talk about the walk and turn test. Now, would you agree with me that the NHTSA manual states that you're supposed to perform this test on a reasonably dry, hard, level, non-slippery surface?
Yes, sir.
Okay. And if you can't find such a surface, you're either supposed to relocate or only perform the horizontal gaze and nystagmus test, right?
Yes, sir.
You'd also agree with me that the NHTSA manual also states that people with back, leg, or inner ear problems had difficulty performing this test.
Yes, sir.
Now, officer, you previously testified that this was a nice flat surface, right?
Yes, sir.
Okay. So, do you not think that, do you not think that it is sloping towards you from your vehicle right now?
No, sir. It was perfectly flat.
So if we go back, review your camera, the jury goes back and reviews your camera. We're not going to see a slope on that parking lot.
You might see it, but the thing is that I know that was flat. I worked in construction prior to becoming a police officer. Typically, those drive-throughs like that, they make them real flat. The concrete, it's just basically a broom brush concrete. So it's pretty smooth, the finish on it. They don't want water, pulling up, so it's flat. So it was kind of pretty much like a perfect condition for the most part.
Officer, so I want to go back to something you just said. You said that for water drainage, they don't make the parking lot flat, or sorry, that they make the parking lot flat to allow for drainage, right?
On that flat spot right there, sir, that whole approach underneath there, that's completely flat. The drainage will usually be off to the edges of the site where they construct stuff.
Okay. So wouldn't it need to be slanted slightly for the water to drain off, or wouldn't it just pool up if it's actually flat?
Very minimal slight drainage, as far as the angle on it, but it's very flat there, sir.
Now, you, as part of performing the walk and turn test, as part of explaining the instructions, you have to determine whether or not you think the suspect is a qualified candidate, right?
Yes, sir.
And part of that involves asking questions about his medical history and any injuries he may have, right?
Yes, sir.
And again, just the NHTSA manual does state that people with back, leg, or inner ear problems have difficulty performing the walk and turn and one leg stand tests.
Yes, sir.
Now, when you asked Mr. Hiller if he had any injuries, he did tell you he had an injury, correct?
Yes, sir.
Now, we've heard your video. Obviously, you didn't believe it, right?
I didn't.
Okay. So you just say that you have, do you have any kind of medical background, officer?
I graduated with a degree in biology and chemistry,
Okay.
but it's medical training, not completely.
Have you ever been an EMT?
No, sir.
Have you ever been a doctor?
No, sir.
Have you ever been a nurse?
No, sir. I'm married to one.
Now, when he tells you that he has the leg injury, when he's talking about that, he states that the primary injury is to his ankle, and then I guess there's like a secondary injury with his knee and possibly some of the surrounding muscles in his leg, right?
Yes, sir. And as he explained that, he was stating that he was putting all his weight on his right leg, the very leg that he said was injured.
Okay.
He actually even kind of hopped around a little bit too on that very leg as he explained that.
Now, officer, have you ever had an injury before?
All the time.
Okay. And so, I guess more specifically, have you ever had an injury to your leg or to your arm?
Yes, sir.
So you'd agree with me that oftentimes when it comes to an injury to the leg, to the arm, that there can be both a primary injury as well as like secondary muscular injuries, right?
Yes, sir.
So sometimes, for instance, just example, you could hurt your wrist and experience pains up here that are still related to the wrist, right?
Yes, sir.
So it's possible if you had an ankle injury that he could have those additional pains in his leg or additional injury to the muscles in the leg, right?
Yes, sir. Possible. Yes, sir.
Now, you'd agree with me that probably should have left the boots on, right?
That's his call, sir. I don't know. He's claiming in 1 minute that it's his hip, his knee, then he says it's his ankle. He's the one who decided to remove his boots. I didn't tell him to. I think I even told him on video, don't you think you should leave them on if it's your ankle? But he chose to.
Now, officer, as we've already established, at this point, this video is not to actually make a determination in the field. This video is so you have evidence to show this jury, right?
Well, the videos are, as officers, we're required to have them. So if it becomes evidence, it becomes evidence.
Okay.
But it's required.
You were also testifying just a moment ago that you went back and performed this test a second time, you went back and performed the horizontal gaze nystagmus test a second time to build evidence in this case, right?
That if I decided to place him under arrest, I wanted to make sure I had evidence. Yes, sir.
Okay. So if he had left his boots on, would you be here testifying that you didn't get an accurate result because he had big, heavy boots on?
I don't recall how big the heel was, but I mean, it's up to him as far as, typically with the walk and turn test, usually women with high heel shoes will ask them to remove them if the heel's, more than an inch or two. But with a boot like that, where the sole is thick, but it's even, but again, he's the one who decided to remove them.
So, officer, I'm going to ask you again. If he had left them on, would you be here testifying that that skewed the results of your test?
I don't think it skewed it.
Okay. Do you think him taking the boots off skewed his performance on that test?
No, sir.
But that's also because you don't ever believe that he actually had a leg injury, right?
It's not that I didn't believe he didn't have a leg injury. I'm not calling him a liar. I never met him before. But the mere fact that for someone who was injured, what he said he was, he sure did display a lot of use of it.
Now, officer, going back to your report and those check boxes where you indicate different things that you observed, you'd agree with me that there's a section, I guess, titled both body control and then there's different categories next to it for balance, walking, and turning, right?
Yes, sir.
And for Mr. Hiller, on these boxes, you checked hesitant and unsure.
Yes, sir.
Okay. Now you have other options on there, right?
Yes, sir.
And the other options are falling, staggering, swaying, and sure, I guess.
Yes, sir.
Will you describe his balance, his walking and his turning as just hesitant and unsure?
Yes, sir.
Officer, if you had an injured leg, do you think that it's fair to say you would walk hesitant, possibly unsure?
If I had an injured leg, I would have really disclosed that, and I probably wouldn't have. I would have told the officer that I can't do it.
Now, officer, did you tell Mr. Hiller at any point that he was allowed to refuse these tests?
No, sir.
And he is legally, right?
Yes.
Okay. But again, after telling you he had this leg injury, did you give him the option to not perform this test?
No, sir, because again, as he's explaining to me that he had the injured leg, he's displaying the use of it. So I don't know what to say.
Would you agree with me that he is trying to comply with your orders?
Yes, sir, but I mean, he's a grown man, and I mean, every individual has a right to say no if they can't do it. The arrest I had yesterday, the lady said, I can't do it. Left it at that. I'm gonna push him into it. It's their right to refuse.
But again, you don't tell him that he has that option, right?
I didn't
You
tell him.
instruct him that this is the next thing he's going to do and how to do it, right?
Yes, sir.
And at any point while you were while you were investigating Mr. Hiller, did he ever refuse any of your requests?
No, sir, he was very compliant.
Now, officer, I'd like to direct your attention. This is another page out of your report. I'm trying to the easiest way to describe this one. This would be, I believe at the top, it says San Antonio Police Department, DWI traffic case report. And the first line of actual entry information is location offense observed, or sorry, location offense occurred. Do you see that page, officer?
Yes, sir.
Okay. Now, a little bit further down into that page, we have some just basic vital statistics for Mr. Hiller. Is that correct?
Yes, sir.
And those, you just take those from his driver's license?
Yes, sir.
Okay. Well, I guess, do you actually ask him? Do you observe his height and weight, or do you just go with the driver's license?
If there appears to be an actual discrepancy with the weight, because usually the height's usually spot on, but I'll ask them. Usually the ladies, I don't ask them.
And you'd agree with me that you have height listed as 5'3". Is that correct, officer?
Yes, sir.
And you agree with me that you have weight listed as 185 pounds. Is that correct, officer?
Yes, sir.
Now, officer, do you think Mr. Hiller is in peak physical shape? Do you think he's overweight?
Not to offend him, but he doesn't look like he's in like top condition.
So do you think he looks overweight? Do you think 185 pounds for someone who is 5'3" is overweight?
I'm 2 inches taller than he is, and I weigh 200 pounds, but it's just how we wear our weight is different.
Okay. Now, in the NITS manual, the manual you're trained on, you're instructed that if someone is over 50 pounds or is 50 pounds or more overweight, that you're not supposed to perform these walk and turn and one leg stand tests, right?
Possibly, yes, sir.
Okay. And it's because being overweight affects your ability to balance on these tests, right?
In my opinion, weight doesn't always matter because everybody, how they carry their weight is different. Obviously, there's times where it's very, as a matter of fact, that yes, you can see that it's gonna be an issue. But if that was an issue too, by his part, he could have said, sorry, I can't do it.
So it's not necessary. So the NHTSA manual says 50 pounds or more overweight, and you're gonna get a skewed test result, right?
It's possible.
Okay. Your personal opinion is that weight isn't what affects it, it's the shape of your body, right? Or how we carry our weight. That was what you just said.
Yes, sir.
Okay. I guess if we're more top heavy, we have trouble balancing, is that right?
Just depends. And my father is 70 years old. He's 5'10" and weighs 250 pounds, and he does not look like he's in shape. But my father can twirl around like something else when he dances. You know, so it just depends on the person.
It just depends on the person.
Yeah, each person. Yeah, they how they carry it.
So, let's see. Now, officer, when you have Mr. Hiller perform the one leg stand test, he holds that leg up for, if it's 10 seconds and he puts it down, which is incorrect, right?
Yes, sir.
Okay.
Sorry. Yes, sir.
Now, after he has completed this test, or after you stop him, you ask him why he was standing on his right leg when he's saying that that's the injured leg, right?
Yes, sir.
And we hear him on the video state that he has to stand on the right leg, because if he stood on the left leg, he wouldn't be able to lift the right leg per your instructions.
Yes, sir.
Now, officer, you testified earlier that I'm sorry, I'm gonna back up. When you were talking about the walk and turn test, when you were previously testifying, you stated that 2 out of 8 fluids is equals intoxication, right?
I'm sorry, repeat it, sir.
So when you were testifying earlier, you testified that 2 out of 8 fluids on the walk and turn test is where you think someone's intoxicated.
It's not where I think it's basically that's their instructions.
Okay. So if someone presents 2 out of 8 of those fluids, you're instructed to believe they're intoxicated at that point.
Possibly, yes, sir.
So while you're explaining those instructions, if someone steps off of balance or steps out of the starting position, and then at some point misses one heel to toe step, that would be 2 clues, right?
That if they lost their balance, they held the touchy out of toe?
If they started to, or I'm sorry, yes, if they stepped out of the starting position,
Mhm.
and also they missed one heel to toe step, that would be 2 clues, right?
Yes, sir.
Okay. And so at that point, you're instructed to believe they're probably intoxicated.
Yes, sir. Sorry.
Now, no, you also previously testified that these tests are recognized nationwide, right?
Yes, yes, sir.
Officer, I guess I would have to ask you, are you aware that in the state of Kansas, these are not admissible tests? The horizontal gaze nystagmus test is inadmissible evidence.
Wasn't aware of that.
Now, officer, you testified about these validation studies that are done, and it's these validation studies that support these tests are reliable, right?
Yes, sir.
And in fact, that's where the phrase like being standardized comes from, right? That's what makes them standardized, they're validated.
Yes, sir.
Now, officer, you would also agree with me that I guess let me back up, officer. You had stated there were like several validation studies, right?
Several validation studies.
Yes, sir.
The information gathered from NHTSA was based off of just all the information that they, used with the officers.
I guess what I'm asking, officer, is that there's a there's a Colorado, Florida, San Diego. There's these different validation studies, right?
Yes, sir.
That's all part of your training with the NHTSA manual, the NHTSA procedures, right?
Yes, sir.
So you'd agree with me then, though, that the San Diego validation study still states that these 3 tests done together only produce a 91% accurate reading.
I don't remember the percentages, sir, but if you say it, that's what you're reading.
Could I approach the witness, Your Honor?
You may.
Officer. I'm showing this marked as exhibit number 1. What are we looking at here?
It's one of the standard. It's a refresher for field sobriety tests from 2018.
Okay. And so, taking a look at it, this looks like what? This is the NHTSA manual, right?
This is one of them. Yes, sir.
Okay. And so, do you agree with me then that the numbers stated right here state that the San Diego validation study, 91% accurate for an arrest decision?
Objection, Your Honor. Exhibit number 1 has not been entered into evidence, and reading from it would be improper at this point.
When it's stated that the NHTSA manual was training on, this is what everything that he's done is based on. We're just asking to identify the exhibit. He's identified it as a NHTSA manual. He's not saying I've edited it, done anything to it. Turn around and asking him, refreshing his memory just as they did with police report.
I'm going to sustain the objection.
Sorry.
No, officer. Now, officer, when you're at these training and refresher courses, I guess, how long are the refresher courses?
It usually lasts 12.
Okay. So it's just one day?
Yes, sir.
Okay. And so you guys go over a NHTSA manual, much like the one I just showed you, right?
We go over laws, briefly any changes within the laws. We also go over our own protocols as far as what we do through general manual as far as how we conduct our investigations. We will go over the administering the test to one another with an instructor present who has to sign off on whether we're capable of doing it properly.
Now, officer, these tests are invented by scientists, right?
The tests were invented by scientists. I guess the information was gathered by people with PhDs and stuff.
So Who wrote the tests?
I know that the information was gathered through, again, they basically gathered officers' information. And then, obviously they had, I guess you would say scientists, put together, we did.
Okay. And it's the scientific studies, again, that what makes this a reliable test, right?
Yes, sir.
Now, officer, is it true or not that the San Diego study says that it is 91%, all three tests together in making an arrest decision?
You showed me that book, and it had percentages. I didn't get to read the whole thing as to what it's saying. So I just saw 99% or whatever the percentage was, but I don't know what the rest of it said.
Okay. So are you saying that that is true or untrue?
Can't say either because I didn't get to read the information.
Okay. Now, officer, do you think it would help you to answer these questions, to have your memory refreshed as to what you learned in these field sobriety tests?
I mean, you can give me that book and I can read off of it. If you're, the thing is that when I went through the academy, the booklet that we were using was what, 2006. Every year, every other year, the question. So if it changed, it changed. I mean, I can't guarantee because I don't have that book. What you have in front of you, I mean, that's the most recent one. Okay. What I learned back then, I mean, the percentages would have been changed. So,
Officer, these three validation studies we previously mentioned were all conducted in the 1990s, correct?
I didn't get to read it. You had it, and all you wanted to do was percentages.
Did you go to the refresher course this year?
I sure did, sir.
Okay.
But we didn't cover that stuff. Not that portion about percentages.
So you may not remember the exact numbers. Do you agree with me then that it's still not 100% accurate?
I would agree that it's probably not 100% accurate.
All right, let's move on from here. Now, officer, you'd agree with me that after performing the walk and turn test and the one leg stand test, we see Mr. Hiller on the video putting his boots back on, right?
Yes, sir.
And to do that, he basically bends at the waist and is reaching down to the ground to grab his boots, right?
He was actually almost like kneeling down, I think,
Okay.
for the most part.
And so at any point in all of this, did you ever see Mr. Hiller fall down?
No, sir.
And again, that's why you check the box for hesitant and unsure balance and walking, but not falling, staggering, swaying.
Exactly. Yes, sir.
Oh, pass the witness, Your Honor.
All right. You may proceed.
Officer,
Yes, sir.
you,
I'm going to ask you to use the microphone, please. Thank you.
can you hear me now?
Yes, sir.
Okay, I hear you. Thank you.
So just a few things to redirect. I know we're trying to get you out of here so you can pick up your child.
I'm late. Sorry.
Originally, you pulled him over for speeding.
Yes, sir.
At a certain point, you decided to investigate for intoxicated driver.
Yes, sir.
You mentioned the red bloodshot eyes, and previously indirect, it was the smell.
Yes, sir.
And you specifically went over the smell, why you pulled him out. Is there a difference between smelling a vehicle and smelling it from someone's mouth?
Well, I mean, yes, because of the fact that being that there was another person in the vehicle, you know, I've stopped people who say that they're the designated driver and you look around in the vehicle and you know that odor's coming out of there. You want to determine whether the person who's the designated driver isn't intoxicated. You get them out and you can immediately tell that they weren't the ones drinking, but it was the people in the vehicle. In this case, you know, obviously I wanted to remove them from the vehicle to make sure it wasn't, you know, the passenger. So once I got him out of the vehicle, I was able to determine that it was actually coming off of him as well. You know.
Okay. And had you pulled him out and you hadn't smelt it on his breath, would have you given him the speeding ticket, sent him on his way?
In all honesty, I think I give out about 3 tickets per month. Typically, I give a lot of warnings.
So you might have given him a warning for speeding.
I was probably going to give him a warning because that, you know.
Okay. In your experience as a DWI officer, do any of the defendants that you pull over make excuses?
Quite often, yes, they do.
Quite often. Why didn't you believe the excuses this time?
Basically, I mean, again, it's just the fact that as I'm talking to him, it was very apparent that, I mean, again, he was using that right leg, you know, placing a lot of weight on it. I played college football. Was a power lifter. I've busted up my knee before. I can't go on it. I can't go on it. You know, him saying that he injured it, you know, it's like, it was hard to believe that because of the fact, again, he just kept putting a lot of the weight on that leg. And then he wasn't grimacing, showing any signs on his or expression that it was painful. It wasn't until the very end when all of a sudden he just decides he sits down, you know, basically blaming me that he's going through pain. So.
Are there different levels of intoxication?
Yes, sir.
Specifically, does everyone react the same way?
No, sir. You can have somebody who's an alcoholic who can ace the walk and turn test, one leg stand test. The only one that usually gets them is the horizontal gaze nystagmus test because that's controlled by smooth muscle tissue. You can have somebody who's just started drinking recently. Maybe that was their first night of drinking. It's that sloppy drunk, you know. It's exhibited in different ways. But the happy drunk, the angry drunk, you know, the one that's sad. Everybody does it, you know, is different how they react.
Does a defendant have to be blackout drunk before you arrest them?
No, sir.
Would it be safe to wait for every defendant to be blackout drunk before you arrest them for driving while intoxicated?
No, sir.
Is it your duty to keep the community safe and protected from intoxicated drivers.
Yes, sir, it is.
And did you fulfill that duty here?
Yes, sir, it did.
By the totality of the circumstances, everything you testified, was it your opinion, and is it your opinion, that the defendant was operating a vehicle under the influence of an intoxicant?
Yes, sir.
He was intoxicated,
Yes, sir.
that he had lost his mental and physical faculties needed to operate a vehicle safely.
Yes, sir.
Would you put your child in the car and let that defendant drive?
No.
Were you going to let him drive his friend home?
No.
No further questions, Your Honor.
Mr. Nichols.
So officer, you testified quite confidently at the end of their redirect that you feel you came to the right conclusion. You feel that Mr. Hiller was intoxicated, right?
Yes, sir.
And you don't think you made a mistake that night?
No, sir, I know I didn't.
Well, more mistakes than all the ones we already detailed in your report, right?
Those were minor mistakes, but I know I made the right decision in arresting them.
Officer, if someone refuses to perform this standardized field sobriety test, what do you typically do in that circumstance?
You're talking about all of them or one of them or?
Yeah, all of them.
You have to base it on everything else that you have. You have a bloodshot across the eyes, you detect that odor and toxins. Or you see some of the signs that maybe they use narcotics. They refuse. I mean, you don't have much of a choice. If I allow that driver to take off and I don't arrest them, and it's in my mind that they might be intoxicated, they drive off, they have an accident, I get fired.
Okay.
So I can't have that in my mind, for me to lose my job, no. Or to jeopardize someone's life, no.
So out of an abundance of caution for your own job, you would have arrested him in that circumstance.
For my job and the safety of the people, yes.
And it's true also that had he refused those tests, again, you'd be sitting right there telling this jury that his refusal is evidence of intoxication, right?
Based on the totality of the circumstances, sir.
But you would be stating, had he refused these tests, that his refusal is evidence of intoxication.
It's not always an evidence of intoxication. I put everything together. The fact that I detected the odor of intoxicants, the fact that he admitted it. I mean, if he refuses them, that's what I have. So I have to place him under arrest.
Pass the witness, Your Honor.
All right.
We have no further questions, Your Honor.
All right, thank you, Officer Flores. You have a wonderful afternoon. Thank you for being here. And your next witness?
Your Honor, the state rests at this time.
All right. Mr. Nettles, do you have any witnesses?
Your Honor, at this time, I think we would need to make a motion also for the presence of the jury.
All right. We're gonna have another break and it won't be very long, I don't think, so y'all enjoy it. See you back in a minute.
All rise for the jury.
Okay, we're back on the record. Do you want to proceed at this time with your motion?
Yes, Your Honor, at this time, defense would make a motion for a directed verdict, specifically what we would direct the court's attention to in the elements of driving while intoxicated. I'm sorry. Specifically, Your Honor, what we'd argue to the court is that the elements of this crime have not been met. There has been no evidence this crime occurred in Bexar County, Texas. There has been no competent, credible evidence of intoxication in this case, Your Honor. We heard this witness testifying about certain pieces of the NHTSA manual, but then would also testify that he doesn't remember other things from the NHTSA manual. Your Honor, this witness also testified that his report is covered in mistakes. So much so that, Your Honor, there is nothing before this jury with which they could make a legally sufficient guilty verdict. If this verdict is guilty today, Your Honor, this would be reversible or insufficient evidence. We're asking that the court stop this before it gets to that point. There is no evidence to go forward here, and we would ask that the court grant the directed verdict and enter a verdict of acquittal.
Thank you. Your response?
Our response is, Your Honor, I specifically asked him where he was located. I went back to it. And the street he mentioned, I said, is that in Bexar County? He said, yes. Bexar County element was met. As to the date, yes, he did admit to having some mistakes, but we did clarify the actual date as September 1st. He did identify the defendant, that the defendant was operating a motor vehicle, and it was a public place while the defendant had a loss of mental and physical faculties caused by the introduction of an intoxicant. We have met all of our required elements to meet the driving while intoxicated, and we would urge that you deny the defendant's motion.
And further, Your Honor, the defense is basically trying to assert.
Your Honor, I'm gonna have to object under the Bexar County local rules. We can't have two attorneys for the state going against one attorney from the defense. If they have separate arguments, they can make it out one attorney arguing to the court. It is improper and unprofessional to have two attorneys arguing against one.
All right, well, do you all want to confer a little bit?
Yes, Your Honor.
It's cold in here. You like it?
Your Honor.
Yes, sir.
I'm sorry about that. And we would just like to remind everyone that the standard is a scintilla of evidence, and that we have put on a scintilla of evidence and beyond, and actually proven all of the elements. So, or put them on for them to evaluate.
So, basically, there has been evidence, and I think it just boils down to credibility, and that is for the jury to decide. So, I'm going to deny the motion for instructed verdict. We do have our jury charges. We have 3 of them. let me see, at this time, we're taking a break.
Off the record,
No. I do need to have them come in so I can instruct them about what's going to happen next. So we'll have them come in briefly, and then we will work on the charge.
careful with the stickies.
Sorry?
Be careful with the stickies, so they don't get misplaced.
Oh,
with the jury
oh, yeah. Okay. Okay. Well, I'm going to stand up. Feels good. Want one of those candies, Nancy? Would you all like candies? Not right now, right? Till we finish. Let me just bring the panel back in, and we'll go ahead and excuse them in a few minutes.
We'll let one use the restroom.
Oh, okay.
Bathrooms and all come back. That's why I said 6 chairs, 2 bathrooms.
Well, it's been a while since we had a break.
Ready? We'll go. All right, jury. Maybe seated.
Okay. Members of the jury, all the evidence is now before you. However, you have not yet been given the law in the court's charge and heard closing arguments from each side. We are going to take another recess at this time to allow me to prepare the charge and counsel an opportunity to review that charge before it is read to you. All the instructions I have given to you at the beginning of this case still apply. You are not to discuss this case among yourselves or with anyone, or to remain within hearing of anyone discussing the case. At this time, we stand recessed until, I'm thinking this will be a nice long break, at least 20 minutes. So if you want to go downstairs and get yourself something, you'll have enough time to come back, okay? All right, thank you.
All right.
Say that again.
When they're out.
Your Honor, I believe we're gonna have to bring him back in. We did not put on the record that defense is resting and closing.
Oh, you're right. I sort of skipped past that, didn't I? Okay. I just assumed I had said that. Okay. Well, will you tell him? Are they all still there? Are they all still there?
Yes.
Okay. Well, that was a short break. Did you all enjoy your break? You may be seated. All right, I was eager to keep moving and I skipped something that I really needed to do on the record. So at this time, does the defense have any more evidence to present?
I know your honor, defense would rest and close.
All right, and the state?
We would rest and close.
All right, so. Now, all the evidence is before you. We have no more witnesses and we have no more testimony. We have no more exhibits. So after that short break, you now will have a longer break. All right? Just remember the instructions I gave you all. All right, thank you.
All right, Jerry?
I hope that was sufficient. Is that okay?
That's fine, your honor.
That makes it somewhat embarrassing, but you know, we have to get it right.
Yes, sir. Yes, sir.
Okay, well, we do have, what are we gonna do? Go over the charge? I guess we need to make copies of these. Now, there was no testimony about blood and no testimony about breath, right?
Correct.
So we only have this one about the loss of mental and physical faculties. And the defendant did not testify. So will you make a copy so that they can?
I think, I'm not sure if it's still in there, the one about the defendant not testifying.
Yeah.
She said it's easier to take it out than it is to put
Oh,
it in,
okay.
so I might have to take it
All
out.
right, so-
You know.
I just need a copy of each one of these so that they can have a copy while we are, while I take objections or submissions.
You want me to take out that paragraph where the, I'm not
No,
sure.
not
it's
yet.
in.
They're gonna look at it.
They're gonna look at, oh, okay,
Yeah.
okay, I got you, I'm sorry, yes,
Yeah.
yes, we are looking at it. Decide what's in and what's not, okay.
Okay. And I'm not gonna sit down for a minute, so if y'all want to sit down, you're certainly welcome to be comfortable. Sorry? Sure, yeah. Those are good, aren't they?
I'm eating my dum-dums. The
You what?
raspberry dum-dums.
You have raspberry dum-dums?
They're good.
What are those?
Like butterscotch?
Oh, really? Oh, it's a lollipop?
Yeah.
Yeah.
They're called dum-dums. I just
can't
break
eat
off the stick and use
that.
them as a
Oh,
regular
you
piece
do?
of hard candy, yeah.
Oh, okay. Oh, thank you.
There's a bag of 500 in the bottom drawer.
Oh. Mr. Nettles, are you into candy?
I am, I'm fine right now though. Although
I
I
don't-
have passed my limit of sugar today.
I've been trying to be good about it.
12, especially.
I even had coffee without sugar today. So I'm making up for it with candy now.
Never, so I used to travel 36 states installing and repairing bowling lanes. We're based out of Newport News, Virginia. And we were at this one place in South Carolina, a motel, and their continental breakfast didn't have cream or sugar for the coffee. And I would always have a little coffee with my cream and sugar.
Yeah, me too.
More coffee, more cream and sugar than coffee.
Mhm.
And my owner of the company, he was a chemical engineer. And he told me that if you were to take a little styrofoam cup of good black coffee, all starts with good water, and then put nothing in it, 1 cup a day for 7 days, and you'll never put cream or sugar in your coffee again, and you'll know when you have a bad cup of coffee.
Really?
Yeah,
So,
just one
so,
a day for
it's-
7 days, and you'll never put nothing in it again. And it's true.
yeah. So the important ingredient is the water.
Yes. You take this burnt tap water San Antonio's got, give you the worst cup of coffee you ever had.
Yeah, it's very hard water. Yeah.
I mean, because I got 25-gallon jugs in my garage that I fill up from those windmill machines.
Mhm.
My pets get bottled water. I cook with bottled water.
Really?
Yeah. My cats have a fountain that they drink out of, like a
Wow.
drinking fountain.
Hmm.
Keeps it filtered.
Keeps them nice and healthy, I guess.
Keeps the water cold too, yeah.
Oh, really?
Because it stays aerated, oxygenated, from it running into the pool.
Interesting.
Called a Pet Safe 360. And my dog, Pickle, he only gets bottled water. Their food's best you can get. It's like $6 a pound. They eat better than me.
Mm.
I buy ballpark franks at $4 a pound. Hamburgers, dang, they're $6 a pound.
Yeah.
Are they on them container ships too? Because
You
the
know,
cows on the container ships, because the price is going up like you wouldn't believe it.
I know.
Like steak.
I don't know if that's not a deliberate manipulation of the market.
I don't know. People don't want to work because they're being paid to stay home more than
That's not true.
most people. That's why,
Unemployment applications in Texas have gone down.
well, in Texas,
Mhm.
because employers are paying more.
Nah, not necessarily. I mean, I know that they've said that they've raised the wages to $15 an hour, but I don't know how consistent that is. I mean, I heard Walmart did it. I heard McDonald's did it. But McDonald's also, if people want to work there, they have to work only at that one location. They can't work any other locations.
Yeah.
I mean, that's, why do they care?
I don't know. They're all trained the same way because every McDonald's has all the same equipment and it's all rolled out at the same time because they have to follow corporate standards.
Right, but why? I mean, what,
That doesn't make sense to me, but hey, I guess because you're not, the payroll would have to be duplicated
I
everywhere.
mean, but that's not consistent with the theory that people are not working because they're lazy. That's just, if people want to work 2 shifts, but they're not allowed to because, I don't know why.
They don't want to pay the overtime. That's,
Is that what it is? No, I don't even
I
know that
believe
it would
so.
be overtime because it would be at a different franchise.
well, then that,
They're not the
then
only
that
ones
other
that do
employer
that.
would bear the cost of his overtime hours because it's more than 40 hours per week.
Oh, yeah, but I mean, they would be,
But does that apply only at
They
one
would-
location or one employer or
I think it's a
how does
company
that work? I don't
policy
know how the
because,
Federal Employee Act works that
I
way.
mean, because I did a lot of child abuse neglect cases, and people would complain that they can't make more money because if they're, and the other thing is they always, and that may be the reason, they're very arbitrary about the schedules. They don't give them their schedules till like when they have to start. So, I mean, they basically,
That wasn't how it was when I was growing up, and my first job was McDonald's, and we would get our schedule 2 weeks in advance.
I mean, it keeps people impoverished, and why do they care? I mean, they should be happy that people are
When
willing
you
to
give
work.
someone a schedule the last minute, you're not giving them the opportunity to take time off for family emergencies, and, you know, family plans or something like that, to be scheduled in advance.
And Amazon, you know, hits me like one of the richest people.
Yeah,
I mean,
trillion,
that whole
his business is
thing-
worth $1 trillion.
The whole thing with the drivers, I mean, they've got this thing now that they can have their own trucks.
Mhm.
But then
There's a
they're,
place on Eisenhower where they pick up.
they're restricted on how much they can do, so that they don't really make a whole lot of a profit from it. That's wrong.
Well, if I made more doing that than working security at a Walmart, I'd sure be driving my car and my
Well, that's
big,
what-
my big
That's what
truck.
people have done. I mean, they've invested in getting these trucks so that they can be their own subcontractor.
Mhm.
But then there's all kinds of rules that keep them from working.
As much as they want.
They take a surcharge on what they do. Now, that's just wrong. Okay, I'm glad the county hasn't gotten there yet.
I work 7 days a week.
Do you?
I work 14, 16 hours on Saturday and probably 8 to 10 on Sunday.
Yeah. So, well, I mean, if you're willing to do that, why
I
not?
like nice things, so I'll work to achieve them.
Right.
Buy the best, you buy it once. No, I'm just moving over here so I can move the camera. Witness, the monitors and see. I wasn't rooted to take it down because we were.
right, let the record reflect that the attorneys for the parties are present in the courtroom at this time. The jury is not present. The court has prepared its charge and submitted it to counsel for the parties. So having had a reasonable time to review the court's charge, does either party have any objections or requested submissions?
No objections from the state, Your Honor.
All right.
Your Honor, I believe we're still reading through it.
Oh, you still need more time? I'm sorry.
I just want to page 5 of 7.
Oh, okay. All right. We'll wait for you. It's not a problem.
Be seated.
All right, and at this time, having had a reasonable time to review the course charge, does either party have any objections or requested submissions? I'm sorry, sir. All right. And,
State has no objection, Your Honor.
all right. So then we are going to proceed at this time with the trial of this case. Bailiff, please bring in the jury. Maybe before we do that, we do need to make copies for the jury. So I'm going to, will you ask her later to give us 4, 6, 9, 10 copies, please. Or the clerks. Whoever does it. So I am very happy you all are using the microphone because our record, my real time is just not functioning today.
I'm sorry, there's, I need to find where that, website is for it.
Yeah.
It lost the memory from it.
It lost what?
When I cleaned it out, it lost the memory.
Oh,
The website that pops up automatically when I just write connect, type connect on it.
yeah. I mean, I think we're having trouble with the internet more now than we ever have before. But
Yes.
it is what it is. That's fine. It's not a problem. So are you working with that firm now too?
Yes.
Oh, okay. They do a good job. And that book that you read, it's pretty good, pretty helpful, right?
Oh,
Right. It's very professional for me to refer to it as that book you read, right? So I'm breaking records now on making mistakes. We did a plea on, I think it was yesterday. Yeah, it was yesterday. I didn't write down the fine, so later on we'll get that straightened out.
Thank you very much. Yes, please. Nancy,
Yes,
I'm just asking, maybe you could help Deputy Butler give out those for the jurors. He's got it. All right.
Ready?
Yeah.
All right, Jerry, please. You be seated?
All right, we will proceed at this time with the trial of this case. Let the record reflect the attorney for the state, the attorney for the defendant, and the defendant are present in the courtroom. All members of the jury are present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the charge of the court containing the law applicable to this case. In continuing to discharge your responsibilities as jurors, you will continue to observe all the instructions that have previously been given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. If it should be found that you have disregarded any of these instructions, it will be during misconduct, and it may require another trial by another jury. If any of you observe one or more of your number violating any of my instructions, you shall immediately warn the violator and caution him or her not to do so again. Please listen carefully as I read the charge to you. The original will be delivered to the jury when you retire to begin your deliberations. At this time, members of the jury, the defendant, Robert Joel Hiller, stands charged by information with the offense of driving while intoxicated. The offense is alleged to have occurred in Bexar County, Texas, on or about the first day of September 2019. The defendant has entered a plea of not guilty. I now give you the law that applies in this case. Our law provides that a person commits an offense if the person operates a motor vehicle in a public place while the said person was intoxicated. A person is deemed to be intoxicated when such person does not have the normal use of his physical or mental faculties by reason of the introduction of alcohol into the body. A public place means any place to which the public or a substantial group of the public has access to and includes but is not limited to streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. By the term motor vehicle is meant a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks.
Now, if you find from the evidence beyond a reasonable doubt that on or about the first day of September 2019, the defendant Robert Joel Hiller in Bexar County, Texas, did operate a motor vehicle in a public place while the said defendant was intoxicated, then you will find the defendant guilty of the offense of driving while intoxicated. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, then you will find the defendant not guilty of the offense of driving while intoxicated. You are instructed that the information is not evidence of guilt. It is a means whereby a defendant is brought to trial in a misdemeanor prosecution. It is not evidence, nor can it be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of the evidence in the case. The presumption of innocence alone is sufficient to acquit the defendant. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken this witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. The burden of proof throughout this trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given their testimony. But the law of the case you will receive from the court, which is given to you herein, and you will be governed thereby. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, or even mention anything that is not evidence in this trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Throughout the trial, police reports have been marked and discussed. By law, those reports are not admissible as evidence and cannot be provided to you. You will have all admissible evidence before you. You must disregard any comment or statement made by the court during this trial or in these instructions, which may seem to indicate an opinion with respect to any fact or verdict to be reached in this case. No such indication is intended. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. You must not arrive at your verdict by any lot or chance, or by putting down any figure and doing any dividing. After you retire to the jury room, you should select one of your members as your presiding juror. It is the presiding juror's duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached here to and signing the same as presiding juror. No one has any authority to communicate with you except the officer who has you in charge. That is Deputy Butler. After you have retired, you may communicate with this court in writing through the officer who has you in charge. Do not attempt to talk to the officer who has you in charge, the attorneys or the court or anyone else concerning any question that you may have. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and sign his or her name as presiding juror. You will return your verdict in open court. Signed, Judge Gloria Saldaña presiding. All right. At this time, we will allow closing arguments for the state. Would you like to proceed with closing argument?
Yes, Judge.
And how are you all going to divide this up?
I'll do the case closed.
All right,
And I'll finish.
all right, thank you. You may begin on behalf of the state of Texas.
Thank you, Your Honor. Oh, sorry.
So just very quickly, when the officer was up there, I put him on, I asked him questions, he presented evidence through his testimony to you. I asked him the dates, she's there. He said September 1st. He identified the defendant. He stated that the location was in Bear County, that the defendant was speeding. It was a public place, and that by his training and expertise, he believed that the defendant had lost his mental or physical faculties by introduction of the intoxicant alcohol. From the video, you heard the defendant admit to drinking alcohol before driving, and having drank at 7:30. The state has put that evidence to you and presented it to you. And it'll be your job as the judge to evaluate credibility of our witness, whether you believe him or not. And I will pass at this time.
All right, thank you. So, Mr. Nettles, would you like to make your closing argument at this time?
Yes, Your Honor.
You may proceed on behalf of Mr. Hiller.
Please support closing counsel, members of the jury. Finish line, this side. We're almost done here. Just want to talk to you guys a little bit more before you go back there to make your decision. Now, I want to talk with you guys about some of the evidence that we've heard here today. The state's telling you that it's proven this case beyond a reasonable doubt. But let's really think, what have they actually brought? Brought you one witness who is supposed to be an expert in field sobriety tests, supposed to be an expert in training procedures, and this manual lays out. Yet this is the same expert witness who, when it came to questions about the accuracy of these tests, was very evasive, would not want to agree. When it came to questions regarding how accurate these tests are and what those validation studies actually said, would not agree. Wouldn't agree with 91%. In the book. Didn't agree, I think, to less than 100% accurate. Guys, the 9 out of 100 people being arrested by Officer Flores, if he's making an incorrect decision on 9 out of 100. That is not good. That is all the reasonable doubt necessary. If he is making the wrong call on 1 out of every 100, guys, do you remember we were here yesterday and we talked about beyond a reasonable doubt. We talked about all those elements. They have to prove to you beyond all reasonable doubts. We talked about this Tylenol incident with cyanide and ash. 1 in a million chance. Still a real chance. You're told not Tylenol. They're telling you these tests are accurate enough for you to convict the man. But somewhere between 1 and 9 out of every 100, he's making the wrong call. Now, let's look at what evidence it really brought you, what he really testified to. He's saying that he observed red bloodshot eyes. But he also testified, this is around the same time as the African dust episode, and that was affecting people at that time. He also testified that just being tired from a long day is enough to give you red bloodshot eyes. He said you probably have them right now. He's been up all night. That is reasonable count. There are so many things that can go wrong with these tests, and that's why we have other things to show whether someone is intoxicated or not beyond these tests. Because these tests are not accurate. Now, I know I give these cops a hard time. Part of my job, but you know what? I understand they're making a tough call out there in the field. And you've got a lot of things going on, and they have to make a split-second decision without all of the information in front of them. And you know what? Folks, I think that that's good enough for probable cause. But it is not good enough for beyond a reasonable doubt. This is the standard here today. Now, you guys might remember, you go back, that image of the staircase, get up all those different versions, all the way up to the top, beyond a reasonable doubt. You guys will remember that there was clear and convincing evidence, the standard they used to try to terminate someone's parental rights. The measure, the degree of proof of producing in the mind of the jury a strong belief or convictions to the truth of the allegations. Are we even at clear and convincing here? I don't think so. If they were trying to take away Mr. Hiller's children over this, would we think that they presented sufficient evidence? Because they have not. This officer testified that he performed horizontal gaze and stagnant test twice. And that he did it a second time. I'm sure you guys have some evidence to see it today. He forgot to turn his camera on. But he also said it was because he was worried about interference with optokinetic nystagmus. And he testified that that's why they're specifically supposed to position that person who's doing the horizontal gaze and stagnant test so they don't see any flashing lights or moving lights like from headlights on vehicles that drive on the roadway. He said that that's what they're instructed to do in this man. You guys are back there. You'll be allowed to review the video. You guys will have it with you. I'll have it set up on some computer, TV screen. I'm asking you to go back there and watch that video. Because when the camera is pointing directly at him, you don't see any flashing lights. But when he is looking back, which would be the same direction that Mr. Hiller is looking while performing that test, you can see all the flashing lights from his rear activated lights that are reflecting off of the building, reflecting off the giant signs that are right there at security service. You might have turned off the forward-facing one, but there are still flashing lights in his line of sight. And the officer testified he's not supposed to do that. That can and will affect those results. Now, you also heard Officer Ford. Sorry, I guess it's one. You also heard Officer Ford testify that he smelled the odor of alcohol from the vehicle. And then, again, coming from Mr. Hiller once found the car. Mr. 24 hours, last year, please let away, the reception. But officer testifying, the most common clues he always observes, red bloodshot eyes, and slurred speech. He also testifying that Mr. Hiller did not have slurred speech. You guys all hear on the video, he is talking clearly, he is over explaining things and not slurring on any of those words. He is so nervous, guys. Folks, I hope to never go through this experience. Be accused of something I didn't do. To have someone misinterpret my nervousness to be clues of intoxication. I think that when you guys, we all have, when we watch the video here, you guys take the chance to review it again. There is no sign of intoxication. You see him take the steps on the walk and turn test after he sticks his boots on, after he has already explained to the officer in detail it has an injury before. Primary injuries, folks in the ankle, and it also goes up further on the leg. The officer obviously doesn't believe him, right? But the officer doesn't dispute the fact that if you get injured, it's not in just one place. It can go further up your limb. I told you guys, nobody's safe. Some officers, all DWI task force top stop. They get punished. He wasn't even doing DWI enforcement. He was supposed to be doing speeding enforcement. But switch flips. Second he smelled alcohol in the car, told the guy it was game over. And it was. He told you he needed to make sure his camera was recorded properly. So when he came in here to testify, he actually had something to show you guys. Because there's nothing here. Trying to set Mr. Hiller up, trying to parade him around that video and get him to look a certain way so that you guys would convict him. But that is why we chose the 6 of you. You guys will remember yesterday there were 30 people in here. We ended up with 6 of you. Because we knew you 6 would see this for what it is. It's not enough. It is not enough. No. Officer Flores made a big point that Mr. Hiller could have just simply said, I can't perform this task. My leg hurts. I can't do this. We also heard him testify that he didn't give Mr. Hiller a choice. He didn't say, you can refuse this test, or I'll have to make my decision based on what I've based on what I've seen, if you don't want to perform this test. We have the tunnel vision going, set him right through these tests. If you see what he's trying to find, you arrest him, and you can come in here, tell you guys that you did a good job, and you made the right call. Okay? He did not. And again, it always shows the 6 of you. This officer also testified. He's encountered many nervous people out there in the field. And that nervous people who aren't intoxicated sometimes just have trouble following his directions. I don't know if you've heard how many directions there are for walk and turn test. It's pretty lengthy. Try to think about that. But you're also thinking about whether you're about to be arrested by a police officer, or you're also thinking about, I might get shot by this police officer by asking to stick my hand in my pocket one more time. He is so nervous, and I think that that's clear on the video. Finally, I ask that you go back there, you don't take this decision lightly. Most people are on 1, maybe 2 juries their entire lives. You guys will remember this for the rest of your lives. No illusions. It's maybe a story, you tell friends at a cocktail party. It might be something kind of keep more deep down inside, you guys will remember this for the rest of your lives. You don't want to be sitting at home, surrounded by your family, watching some news story about an over-aggressive PWI task force unit that just arrested innocent citizens every day and think, did we get an innocent man? I'm asking you to go back there and vote now.
Thank you. Members of the jury, we're going to hear a rebuttal from Mr. Brochus, is that correct?
Yes, that's correct, Your Honor.
All right.
May I continue, Your Honor?
You may proceed.
So this is it. This is the finish line. In a few minutes, you'll get to go back in the jury room and deliberate with each other and review the evidence. And this is what it looks like. This is what a lot of PWI cases look like. It's not a lot of CSI style evidence, crime scene, crime scene reconstruction with fancy computers. I mean, this is it. It's an officer out of patrol, pull someone over for speeding. And it's just the two of them out there. Nowadays they have their cameras, which help bring valuable evidence into the courtroom. But up until fairly recently, we didn't even have that necessary. But the fact that we don't have all of this extra evidence that defense is implying we should have doesn't mean that the evidence that you've seen is less important or less reliable, less credible. Because that's your job as people on the jury, is to review the evidence. You heard Officer Flores. He's the main source of evidence because he's the only person who was there that day who got up on the stand to talk. And so his evidence, his word, his testimony is main evidence that we have here. And the videos are great, they really are. They bring us as close as we can be to being at that scene, to being there, and allowing us to kind of judge for ourselves what happened, how the defendant behaved. Do you believe that he was intoxicated? But at the same time, videos don't catch everything, right? I mean, sometimes things that you can see, that you can notice in person, don't get captured on a video recording. And that's why an officer's testimony is still very important, very vital, because they're the ones who are there at the scene, in person, noticing all the little details that we're probably not going to catch just from watching a video. And now defense was telling you that you shouldn't trust Officer Flores. He's overly aggressive. He's pulling over innocent people. He's setting people up, including Mr. Hillary. You saw Officer Flores, you heard him speak. It's up to you to decide. Who do you believe? Do you believe the defense? Do you believe that he's overly aggressive? Do you believe that he pulled over Mr. Hiller for no reason? And that he just was determined to arrest him no matter what? Or do you believe that he was doing his job, patrolling? He was out looking for speeders, but when he pulled over Mr. Hiller, he smelled alcohol. As a police officer, it's kind of his duty to investigate further and make sure that if he's just going to write him a ticket or give him a warning, he's not letting someone who's intoxicated drive away and potentially take someone else's life or injure someone. And so he did his job. He investigated further. And the defense wants you to hold that against him I don't think you should, and I think it was clear from Officer Flores' testimony that he's just trying to do his job well. He wasn't there to set up the defendant. He wasn't there to ruin his life for the sake of increasing his personal arrest numbers. You know, he's a straight shooter, and he's good at his job. He said himself, he's probably done this over 15 years, he's done this close to 2,000 times. And so, in practice, it's the key to getting good at anything, right? Whole 10,000 hours idea. I mean, I think a person who's done a DWI investigation 2,000 times is probably going to be able to come to the right conclusion much more reliably than the person who's doing it for the first time, or even the 10th time. It doesn't mean that he's just out here arresting innocent people, boosting his numbers. What this also comes down to is the burden of proof that we have, beyond a reasonable doubt. And it is a high burden, as it should be, because the consequence of finding someone guilty is that they can go to jail, they can be on probation, the loss of freedom, loss of liberty, and that's why it's important that the state has a high burden, and that it's not easy for us to convict people. But beyond reasonable doubt does not the insurmountable Mount Everest type burden that the defense just explained to you. The defense wants you to believe that you have to prove this beyond any doubt. If you have any doubt, even 1 in a million, then you should acquit the defendant. 1 in a million? It's not reasonable. Reasonable? It's hard to define reasonable, but I think every one of us has a good idea of what reasonable is. Because that's what you have to decide. Are there reasonable doubts in your mind about the defendant's intoxication? Is it reasonable that there's something else going on and he wasn't intoxicated? No, there was the smell of alcohol, there was bloodshot eyes, there was the defendant's performance on the standardized field sobriety tests. He showed all the clues. Horizontal gaze and stagnance test. He showed more than enough on the walk and turn and the one-leg stand. Your job is to go back there and decide, do you have reasonable doubts that it wasn't intoxication, it was something else going on here? And if you do have reasonable doubts, then you should find the defendant not guilty. But reasonable doubts are not 1 in a million. It's not, oh, there is some other possible explanation. It's, you have to believe that it was reasonable. And if you think that the only reasonable explanation we've proven beyond reasonable doubt that it was because the defendant was intoxicated, he was operating a motor vehicle in Bear County while intoxicated, then you should find the defendant guilty. And I'm confident that once you go back there, and you review the evidence and you deliberate with each other, that's the conclusion you'll come.
Thank you. All right, ladies of the jury, members of the jury, at this time, all the evidence, the court's charge, and the closing argument of counsel are before you. I'm going to hand to the bailiff the charge together with the verdict form. They will be left with you in the jury deliberation room once all members of your jury are present and assembled in the jury room. The case is formally submitted to you and you may begin your deliberations. So please step down from the jury box and accompany the bailiff to the jury room. We stand in recess until the jury has reached a verdict.
All right.
Okay. Okay, Nancy, I have another problem. On this file, I did not put down the amount of the fine. This was the 30th of September.
Okay. What is the amount of the fine?
And I left it blank.
And then something recalled? Warrant recalled? Warrant recalled? No? It says warrant recalled.
Oh, no, this has already been, this was a plea we heard on the 30th.
It says October 28th on here.
It says the 28th? Oh,
28th.
okay.
What is the amount of fine?
Oh, that's today. I just put today's date so I wouldn't forget about it.
Oh, okay,
Yeah.
okay, this is on the 30th.
Uh-huh. So it was September 30th, and everything else is in the file, except I left the fine blank. So I don't remember what that was. Yes, sir.
We'll be all right if we head upstairs.
Yes, yes.
Thank you, Judge.
We're in recess.
Evidentiary DVD, please.
So I'm going to mute myself. Maybe. I'm trying to mute Aleda. I need to mute myself.
Okay, did you need something, Judge?
hear everything you say.
Okay. And I guess we should stay muted while we're waiting. So I'm going to leave mine, mute my audio.